Hello and welcome to our video, Prerequisites for Successful SAP S4 Hana Implementation. I'm here with Marcus Harris. My name's Eric Kimberling. Marcus, thanks for joining today.
Yeah, absolutely, Eric. I appreciate having the opportunity. As Eric said, my name is Marcus Harris. I'm a software and intellectual property attorney at a law firm called Taft, Stettinius, and Hollister, where I focus my practice primarily in the areas of intellectual property and then drafting and negotiating software-related contracts, software implementation agreements, and then litigating failed software implementations when they go sideways. And unfortunately, as you know, Eric, that happens more and more often these days.
Yeah, unfortunately, and a lot of people have questions around what do we do to avoid that? What are some of the tips before we get started that can help us save a lot of time and money later on?
Absolutely.
That's what we'll cover today, and good to have you here. My name is Eric Kimberling. I'm the CEO and founder of Third Stage Consulting, and like Marcus, we help clients through their digital transformations and SAP S4HANA implementations, although we come at it from a different angle, a complementary angle to what Marcus does, less of a legal guidance angle and more of a consulting best practice angle in helping clients program, manage, and handle the organizational change aspects and just plan for a successful SAP implementation. So what we're talking about today, Marcus, is just what are those prerequisites to a successful S4 HANA implementation, and want to give the viewers some tips on what can they be doing now, ideally before you ever engage in a contract or a firm commitment to SAP or a system integrator, and wanted to get your thoughts on what's the first thing that comes to mind when you think about that one thing that someone should do or really be thinking about, maybe from a legal perspective. What is it? What comes to mind?
Yeah, and I think, really it's from a legal perspective, but it's also just kind of a holistic view of how you get prepared for an implementation. And I think one of the first steps that you really want to engage in is having a really good understanding of why you want to implement a new software package in the first place. I mean, why ERP? Why are you going, in this case, to SAP as opposed to another package? And I think if you really are trying to do this because you want maybe the latest and greatest technology, I think you're going to make a mistake. I think what you really want to think about is, how is this software going to transform your business? What business processes is this software going to address, and where is it going to take you to get you to that next step? It can't be simply about technology. It really has to be about digital transformation, business transformation, and really addressing fundamental issues with your business that the current software package just doesn't do. Is that what do you agree with that, Eric?
Yeah, absolutely. I mean, it's too many times you see companies that maybe they're using an old version of SAP like R3 or ECC, and they decide, well, S4 HANA is the next big thing. We just need to upgrade our system. Or in some cases, they're using an old, a non-SAP product, and they want to make that kind of quantum leap to a modern SAP ERP system. And they think of it as just a pure technology replacement. And those tend to be the ones that get in more trouble than the other ones, because they're not thinking strategically around how they're going to use the software and leverage it.
Exactly, and that's what we see consistently. And all these failed implementations have kind of core similarities, and certainly this is one of them. And one of the other things that they all have in common is really a lack of due diligence on the front end. I think what you need to be aware of when you're trying to select a software package is that the software company's goals and your goals, while they will align down the road, they very much are trying to sell you something. There's not going to be a demonstration where the salespeople don't try to show you the latest and greatest and really try to wow you. And I think you need to do these software demonstrations. You need to do the necessary due diligence before you go into them. From my perspective, and in the lawsuits that we litigate, things like demonstration scripts become incredibly important because they allow you to rank functionality, rank different systems. It really kind of is the backbone of a software demonstration system or software demo. The other thing that kind of goes hand in hand with that, at least from my perspective, is that you've got to see the software that you're going to buy
Mm-hmm.
in a live environment. So it's critical not only to go to a software demo or have the sales team come to your office and do a demonstration of the software, but you need to go to customers of that software vendor and really see, kind of where the rubber hits the road, so to speak. To me, I think that's really critical for just getting an understanding of how that software works and how it's going to meet your needs. Is that something that you advise your clients to do as well?
Yeah, absolutely. And in fact, you bring up a really good point. The little nugget, a little piece that you talked about that I wanted to dig into for a second is the part about making sure that you're buying the software that you're seeing. And I know you've seen this as much as I have with S4 Hana, especially because it's such a relatively new product compared to some of the older SAP products. There's a lot of uncertainty in the marketplace as to what am I really getting, what functionality actually exists in S4 Hana. And it's being S4 HANA in a lot of ways is being developed so quickly, and the functionalities, being expanded, which is great, but we need to know what we're getting right now and what we're not, at least to have a clear picture. So what are your thoughts on that? How do you, from a legal perspective and or just a buyer's perspective, how have you navigated that or advise your clients to navigate that?
Yeah, well, I mean, from a legal perspective, I think it's a little bit more simple to some extent, the answer to that question. And that really is, have an understanding of what you really are purchasing and make sure that you put it in the contract. The challenge that you have is really twofold. One, in the case of an SAP HANA product, like the one that we're talking about, it's being developed so fast, like you said, that what you think you're getting may not be what was actually delivered to you, 6 months down the road. The other issue is software in general is kind of an amorphous thing. It's not tangible, and your task when drafting the contract or negotiating the contract is to try to describe that with as much specificity as you possibly can. If you just say, SAP software, for example, or HANA, that doesn't tell you anything, and what will end up happening is that there's some functionality gap, there's some issue with the software way down the road. You go back to, in this case, SAP, and you say, we've got a problem. And they'll say, well, that software wasn't subject to that particular warranty, or, that's third-party software, or whatever it is. So, I think you've got to be as detailed as you reasonably can be, and you've got to really have kind of a clear strategy for how you're going to deal with these kinds of things.
Yeah, absolutely. And I know you and I have worked together on a few different lawsuits where SAP was involved, or someone tried to implement SAP, it didn't go well. There's a lawsuit. And then what ends up happening is someone gets sued because they allegedly misrepresented what the customer is actually getting. And hopefully people watching this video don't ever have to hire you or I to help with a lawsuit, but hopefully they can engage someone like you or I early on in the contract stage to make sure that's tightened up to where there are clear expectations and it's clear what you're actually getting. Which, have you found a lot of companies don't really get that, or they overlook that important piece of it during the contract stage?
Yeah, and I think they do overlook that. And one of the causes of action, and you're well aware of this, that we will typically bring in a lawsuit, just like you said, is a fraudulent inducement claim or a negligent misrepresentation claim. And not to get too legal, but that's essentially misrepresentation and fraud, right? And the way that you counter that is you have to have a level of diligence when you're drafting these contracts and when you're dealing with that software vendor. If they are making representations to you on the front end during that sales cycle, it's incumbent upon you to try to capture as many of those representations as you can into the contract. So in that drafting and negotiation process, you want to make sure that you've got that marketing collateral, you've got the representations, you've got the emails, and that they're somehow attached as an exhibit, because like you said, when it all kind of hits the fan, so to speak, no one's going to be around anymore. The sales team is gone. Nobody knows what was promised, and they're going to just deny that they made those types of representations. The software doesn't really do that. So if you can point to a document that's actually part of the contract, you've given yourself really a fighting chance to resolve whatever dispute that is and hold that vendor's feet to the fire. We try to do that all the time, in the negotiation process, certainly.
And we see it on the back end in the litigation that we deal with.
Yeah, and there's been I think every time I've worked with you as an expert witness on one of your cases, I think we both come to that conclusion that the companies could have saved themselves a lot of heartache and time and money long term if they just would have taken the time up front to really tighten that stuff up contractually and expectation wise.
Oh yeah, absolutely. And I think, you can't really fault the customers so much, because what ends up happening with the software sales team is, they're going to promise you, the earth, the moon, the sun, and the stars, and they're going to try to minimize the importance of these contracts. And it's not only the salespeople, the legal department that has drafted that form contract for, say, SAP, they will have made that contract look as innocuous, as simple as it possibly can look. There are going to be a lot of references to maybe a URL where some additional terms are, so you don't really see the importance of drafting and negotiating the contract or getting an attorney to actually draft alternative language. I was at a meeting a few weeks ago, and there was a software implementation consultant there that suggested that the contract process usually takes a couple of days, and I think that mentality is pretty prevalent, with the people that I deal with, and you really got to beat that back. If you're going to do it right, it takes way more than 2 days to really do the due diligence on that contract that you need. Do you find that's kind of the approach that you take, and maybe people minimize the importance of the contracts in your experience?
Yeah, and it's twofold. I think the problem's twofold. One is that they don't fully understand the magnitude of what they're agreeing to, but the other part of it too is that so many companies are at the point where they are they're so excited for the project. We've got this new product defined, S4 Hana. It can do all this cool stuff. We'll have machine learning, we'll have blockchain, we'll have all this cool stuff. So there's a level of excitement and momentum that kind of causes people to be a little blinded or have the blinders on. So we've got to think about risk. There is a dark side to this path we're going down. There's a lot of landmines we've got to avoid. Let's make sure we, plan accordingly. And so I think those two things contribute to what you're talking about there.
Yeah, and I think if you've got the right mentality going into this, my goal is not to scare people, but I think you've got to have kind of, a respect for the process and a respect for the magnitude of what you're actually getting yourself involved in. I mean, if you've been on a legacy system for 10 years or however long it's been, and you're about to go down the road of a new implementation, things are different today than they were, 10 years ago, certainly. The contract negotiation process is a little bit different. The contracts themselves are different. And you can't minimize that. And I think, the overall goal for a customer that's entering into a relationship with a software vendor, from my perspective, is to really try to use the contract, maybe not so much the license agreement, but certain aspects of it, certainly. But maybe more so the implementation agreement and the statements of work, really as a tool to manage that relationship with the vendor for not only the life cycle of the implementation, but really for the life cycle of that particular software product, so that when there's an issue with the software, everybody knows what's supposed to happen. There's an issue with the implementation, the deliverables not the way it was supposed to. You pull the contract out of a desk drawer and you say, okay, well, here's how we're going to deal with that. That's really the goal of this. It's to have a meeting of the minds from a contractual perspective, so that there are no surprises in the future. And I think if you're implementing software or you're involved in implementations, having a contract like that is a real benefit.
Yeah, absolutely. And what about when you look outside some of the pitfalls that you're describing, as far as making sure you know what you're getting yourself into, you've got a tight contract that reflects your best interest. What about negotiations in general, though? Negotiating a contract in general. What are some of the just general best practices you have for just the general negotiation process?
Yeah, here's what I tell my clients, Eric, is that, look, I can draft you an ironclad contract that protects you, 9 ways till Sunday, that shifts all of the risk of this business transaction to the other side. I'm happy to do that. But the problem with that approach to contract negotiation is that no one's going to sign that contract. You're not going to get a deal done. And so,
instead of having that mentality, I think what you've got to do is have a collaborative mentality. And really, the contract negotiation process sets the stage for what your relationship is going to be like with that vendor, for as long as you have that software. So, it's an important process. That's the first thing. I think really the other, really guiding principle that you want to focus on is minimizing just restrictions. You don't want the software to necessarily run your business and impact the way your business decisions in the future. You want to have as much flexibility with the way that you're going to be able to use that software on a going forward basis, so that there are no surprises. You don't want to have unexpected maintenance fees. You don't want to have unexpected licensing fees, license metrics, additional users. You want to account for all of those things on the front end, and if you can do that, you really are doing well for yourself, because it's all about flexibility and minimizing surprise.
Right. Yeah, I agree with that. And there's so many times where you see companies that go in with expectation that they really want to beat up the vendor, or and there's a fine line there. I agree with you. You want to get a deal done. You want to represent your own best interest, make sure you're protected, but at the same time, it's got to make sense to both parties. And you and I both worked with clients that want to go in and with guns blazing, and they just want to get everything for nothing, and poison the pond, so to speak, with something that should be a long-term relationship.
Yeah, that, like I said, that's the exact wrong mentality to have. And I think SAP, my experience with SAP, and it can be kind of a good thing and a bad thing. Their contracts, though, I said earlier that these contracts are becoming more simplified, and that's true. SAP's contract framework is more complicated than say like Info or Epicor, so it's a little bit more difficult to understand. And one of the good things and bad things about SAP is that they're more willing generally to negotiate with you. So you really have to understand what the negotiation points are. SAP has certain things they will not give on hardly ever. It all depends on how much money you're spending and how much leverage you have because of that. But there's certainly pain points, and you've got to know what those are going in order to be able to maximize what you're going to get from SAP, so that you've got that flexibility that we've been talking. So I mean, generally, then you've got to have a good negotiation strategy coming into this process. You need to know what you're going to try to get, what may be more difficult to get, and what you might stay away from because it doesn't really matter to you. And I think again, that's how you set yourself up for success. And I know, on your end, Eric, you're involved in a lot of contract negotiations, and you guys have a pretty high level of expertise in how these things go. And I'm sure you see some of these issues as well.
Yeah, absolutely. And we typically look at it more from just a general knowledge of how pricing should look and assumptions in the implementation, and more of the subject matter expertise around how software should be priced or could be priced, as well as how it could be implemented. Whereas I know you're looking at it more from a legal T's and C's protection perspective, which we're not attorneys and we don't do that, but you do it really well. So it's a kind of a complementary way we've worked together over the years.
Yeah, no, I mean, I think that's kind of the key to why our relationship is worked well. It's, we know kind of where the boundaries are and what our expertise, where it is. What about SaaS contracts, Eric? I mean, do you have any kind of special approach that you take to those, as far as maybe the length of the term, or how do you negotiate some of the commitments associated with those from a business perspective?
Yeah, it's funny. I was going to ask you that, so you kind of turned it on me now. I'm going to answer that. But you mentioned something in your last response that triggered that, though. You were talking a little bit about SaaS, and the interesting thing about S4 Hana, I think, just to back up, is first of all, you have to figure out what deployment method makes sense for you. And one of the cool things that I like about what SAP is doing with S4 Hana, which is different than what Oracle and Microsoft and some of the other vendors are doing, is they're not forcing people onto the cloud. I mean, they're giving you options on how you deploy S4 Hana. You've got on-prem, you've got the private cloud option, and then you've got the SaaS option that you're talking about. So I think if you focus on, on-prem, I think people have a better understanding of how to price that. And you've got an upfront fee, and then there's the ongoing maintenance, and it's a little more I don't want to say it's black and white, but people are just used to that model. But
Sure.
to your point, you get into private cloud or the SaaS model. Now you've got this recurring fee, and if anything, the negotiation process becomes that much more important, because now instead of minimizing just your upfront cost and maybe just a small residual ongoing maintenance, now you're talking a heftier ongoing fee. So any kind of savings you can get or any kind of cost optimization is going to benefit you for years to come.
Right.
But the main thing that we see in that front, I'm curious to see what you think too, is we try to obviously make sure we understand the total cost of ownership, because there's so many hidden costs in the cloud and SaaS model, whether it be usage fees, or once you have, certainly if you increase your number of users, that's an obvious one, but increase your number of transactions or the amount of data, the volume of data, number of transactions. There's a lot of hidden gotchas in the pricing model for SaaS and cloud that we've seen that companies don't fully understand and think through. So from a pure cost benefit perspective, that's one of the bigger ones. But what else have you seen, or what are some other things you see?
One of the things that we see coming up more and more recently, probably in the last 3 years or so, is customers of software vendors that are really concerned about getting an upfront kind of discount. And so in order for them to do that, what the software vendor will do is give them kind of more of an expanded term. So there's an initial term of, let's say, 3 years or 4 years or 5 years. And because that term is kind of a longer basis, it's not 1 year at a time, the software vendor is more apt to give the customer a reduced price, at least during that period of time.
Yeah.
What we see happening, though, is when there's an issue with the software, and just because it's SaaS doesn't mean that it's easier to implement necessarily, or that there's not going to be functionality gaps. I think actually, to some extent, you may be more likely to see functionality gaps in a SaaS model than you would on an on-prem model, because there's more customization on an on-prem. SaaS, you're just kind of getting whatever's rolled out for the most part.
I agree.
So what we see is a situation where there are these functionality gaps. The customer tries to get out of the contract, but it's locked in for a 3 to 5 year period, and it may not even be using the software, but the software vendor is still demanding payment because you don't have the right to terminate. So that's an example of flexibility gone wrong, right? I mean, now you don't have a software product that you can actually use. It's not functional. You're still beholden to the software company for your 3 to 5 year period, and you're still on the hook. We've been dealing with a lot of those types of issues lately, and they're challenging, to be quite honest with you. I mean, the contract says what it says. These customers maybe didn't have the sophistication to actually engage in a lengthy, reasonable negotiation process. They were excited, like you said, Eric. They signed on the dotted line, and now they're stuck. And these software companies, as nice as they are on the front end, the tables turn, and they're gonna want their money, and you've got to have a strategy. Ideally, having gone into it, have a strategy for getting out of that kind of a situation. But if you're in that situation, you really got to talk to a lawyer that's going to stack the deck in your favor as much as possible.
Yeah, totally agree. And speaking of talking to a lawyer, being that we're up against the end of our time here, how would I get a hold of you? If you and I are going to be posting this on social media and our YouTube channels and stuff, may or may not have our contact information. How can someone get a hold of you if they want to just bounce some ideas off of you around their contract situation?
Yeah, absolutely. You can get a hold of me. Probably the easiest way is to go to my website. It's softwarenegotiation.com. And on that website, we've got a whole bunch of videos and educational material that talk about the software licensing process. It really kind of tells you, what's in front of you, what you're getting yourself into. We've got checklists. Like I said, we've got videos that go through in detail, tips and tricks. So, and that's softwarenegotiation.com. I think that's a good resource for people, and my contact information is on that website. What about you, Eric?
Yeah, thanks for asking. Our website is thirdstage-consulting.com. That's probably the best way to look. And similar to you, I know you and I compete for putting out who can put out the most content, the best content, and it makes us both better at it. But so there's lots of blogs and videos and stuff out on our site, has our contact information, and you're pretty active and prolific on LinkedIn as well. So I suspect people could connect with you just by searching up Marcus Harris and Taft Law. Those two things would probably pull you up to connect with you there too, right?
Yeah, absolutely. Thanks for bringing that up. Yeah, very active on LinkedIn, and you can certainly search for taflaw.com, both on LinkedIn or other social media platforms. We're on just about every one of them, so easy to find us, and we're happy to talk to you, certainly.
Cool. Well, great. Well, thanks for joining today, Marcus. And one last thing that you didn't mention in your intro that I think is really important is you used to actually work for SAP doing contract stuff, right? So that's you have kind of
right.
understanding the inner workings of how software contracts really work, and you've seen both sides.
Yeah, we've done. I mean, I specifically have done work for on the other side of the house, working for both what's now, it was SSA Global, but it's now Infor, and certainly at SAP, drafting and negotiating contracts in their contracts legal department many years ago. But that experience serves me well and serves my clients well today. So it's good stuff.
Good. All right. Well, thanks for your time, Marcus. It was a great conversation. Hopefully the viewers find it helpful, and look forward to the next one with you.
Yeah, appreciate it. Thank you very much, Eric.
All right. Thanks, Marcus. Hope everyone has a great day.